Hello, good morning, good day, good evening, whatever. This is just a recording of the review. I'm just reciting the reviewer, and we are now in the provisional remedies. And specifically, this is found in the rules of court and rules 57 to 61. Although there are specific provisional remedies found in other special rules and special laws. So this is only found in the rules of procedure for the civil procedure. And now this presentation is based on the topic areas suggested in the syllabus for the bar examination remedial law. Bar Bulletin number 9, section or series 2020 from the office of the 2020 bar chair. This was issued on March 12, 2020. So the suggested topic areas of study for provisional remedies are found in pages 8 through 9 of the said bulletin or syllabus. And of course, the syllabus reminded us that this is not a um, syllabus for the course, but only a guide for the bar examination. So, without further uh, talks, let's go into the what were suggested in the syllabus. So the first one is the nature and purpose of provisional remedies. Okay? So, as to the nature of provisional remedies, it is said in Regalado uh, that these are temporary measures availed of during the pendency of the action and ancillary because they are mere incidents and are dependent upon the result of the main action. So it is highlighted there that these are temporary measures or provisional remedies. And it is availed during the pendency of the action. In other words, the action is in litigation. Uh, and ancillary, because they are mere incidents, are dependent upon the result of the main action. Provisional remedies, according to the reviewer of Riano in 2016, it is said there that they are temporary, auxiliary, and ancillary remedies available to a litigant for the protection and preservation of his right. This means the litigant, while the main action is pending. In other words, it is not the main action itself, but it is a remedy where you can attach, or it can be an adjunct, auxiliary, and ancillary to the main action while it is pending the main action. They are writs and processes which are not main actions, and they presuppose the existence of a principal action. So, in other words, if there are provisional remedies, there should be a main action or the existence of a principal action. In Estores versus Court of Appeals 459-604, it is said there that provisional remedies are not causes of action in themselves, but merely adjuncts to a main suit. They are temporary measures availed of during the pendency of the action and ancillary because they are mere incidents. Okay. In Marie Chris versus Baldiria, or Marie Chris v. Baldiria versus Jose Antonio F. Rojas, GR number 185595, January 9, 2013, the court said that provisional remedies are writs and processes available during the pendency of the action which are resorted to by the litigant to preserve and protect certain rights and interests therein pending rendition, and for purposes of the ultimate effects of a final judgment in the case. In other words, it also helps, or it is adjunct to the final judgment in the case. They are provisional because they constitute temporary measures availed of during the pendency of the action. And they are ancillary because they are mere incidents in and are dependent upon the result of the main action. The subject orders on the matter of support pendentility are but an incident to the main action for declaration of nullity of marriage. Okay, so this is a nullity of marriage case. Now, what do you mean by ancillary? The free dictionary for the legal professions online, they said that ancillary is, it is subordinate, it is aiding. In the legal sense, it is a legal proceeding that is not the primary dispute but which aids the judgment rendered in and or the outcome of the main action. A descriptive term that denotes a legal claim, the existence of which is dependent upon or reasonably linked to a main claim. Now, take note that the court also said in PEZA versus Carantes et al., GR number 181274, on June 23, 2010, that injunction can be a main action if it seeks to permanently enjoin the defendant through a final injunction and not preliminary, issued by the court and contained in the judgment. So, an injunction, although it is found in the provisional remedies as preliminary injunction, it can be the main action according to the court in this case. So, what is the purpose of provisional remedies? In Calo versus Roldan, GR number L252, March 30, 1946, the court said that the provisional remedies denominated attachment, preliminary injunction, receivership, and delivery of personal property provided in Rules 59, 60, 61, and 62 of the Rules of Court. Take note that this is the Rules of Court before 1997. So, respectively, are remedies to which parties litigant may resort for the preservation or protection of their rights or interests, and for no other purpose during the pendency of the principal action. If an action by its nature does not require such protection or preservation, said remedies cannot be applied for and granted. So the court is clear here that provisional remedies are to preserve and protect the rights and interests of the litigant. And if those two uh, things or those two purposes are not found in the said action, then provisional remedies cannot be had. So this is clear in the Calo versus Roldan case. Now, in some other reviewers and some other uh, courses, they uh, listed the following purposes of provisional remedies. Number one, as in Calo versus Roldan, this is to preserve or protect the rights and interests while the main action is pending. Number two, this is to secure the judgment or a security to the final judgment. Okay, so to the performance of the final judgment. So this is found in the wordings of the rules of the provisions of the rules themselves. Number three is to preserve status quo, especially if we are talking about preliminary injunction. And number three, to preserve the subject matter of the action, especially if we are talking about um, receivership. So that is to preserve the subject matter, and that is the reason why that the subject matter or the property in dispute or whatever the thing in dispute is being uh, given to a receiver. So as a provisional remedy. Okay? So in United Alloy versus UCPB, GR number 179257 in November 23, 2015, it is said there that the dismissal of Uni-Alloy's main action carries with it the dissolution of any ancillary relief previously granted therein. So it's very clear that the provisional remedy being applied for during the pendency of the case were also dissolved as the main action was dissolved. Provisional remedies, also known as ancillary or auxiliary remedies, are writs and processes available during the pendency of the action, which may be resorted to by a litigant to preserve and protect certain rights and interests pending rendition and for purposes of the ultimate effect of a final judgment in the case. They are provisional because they constitute temporary measures availed of during the pendency of the action, and they are ancillary because they are mere incidents in and are dependent upon the main action. So in other words, that when the main action has been dissolved or on any case was dismissed, the uh, provisional remedies that was filed along with it will also be dismissed or dissolved. Now we will go to the jurisdiction over the provisional remedies. So, as a general rule, the jurisdiction of the provisional remedies are is being said that the applications must be filed with the court having jurisdiction over the pending principal or main action. Of course, you cannot uh, file a adjunct, an ancillary action, which is not found in the same uh, court having jurisdiction over the pending principal action. Okay, so this is very clear. This is also a common sense that the the uh, the provisional remedy goes with the main action. An inferior court may grant a provisional remedy in an action pending with it. So even the inferior courts, no, such as the MTC and of course the RTC and going up, can give provisional remedies. Even the Supreme Court can give certain provisional remedies, no, as we will go along with the provisional the review on provisional remedies. Okay, so what are the exemptions? These are not really exemptions, but these are specific things regarding jurisdiction of provisional remedies. The MTC may grant preliminary injunction in feud to prevent defendant from further acts of dispossession or writ of preliminary mandatory injunction to restore plaintiff in possession upon proper application filed within 5 days from filing of complaint. So this is found in the reviewer of Riano. Now that the municipal trial court can grant preliminary mandatory injunction. What else? Only RTC may issue provisional remedies when the action is for specific performance. Okay, so because this cannot be had in the MTC, and you cannot file provisional remedies in the CA or the SC with specific performance because these are not within their jurisdiction. Only family courts may provide the provisional remedy of support pendente lite where the main action is one for support. Why? Family courts are regional trial courts and they can only provide provisional remedy of support pendente lite where the main action is one for support because of the relationship of the litigants. Okay, so this is a jurisdiction of the family court. In an action publiciana where the assessed value of the real property is 10,000 pesos, only the MTC may grant provisional remedies because of the value of the real property. Okay? MTC has an exclusive original jurisdiction over civil actions and probate proceedings, testate and intestate, including the grant of provisional remedies in proper cases where the value of the personal property, estate, or amount of the demand does not exceed 100,000 pesos, or in Metro Manila, where such personal property, estate, or amount of the demand does not exceed 200,000 pesos, exclusive of interest damages of whatever kind, attorney's fee, litigation expenses, and costs. This is found in the Batas Pambansa bilang 129, Section 33. Okay, so because we are talking about jurisdiction, we are also talking about the time of application for provisional remedies. And usually these are stated in the first section of each rule. So in the 5 rules that we will be talking about as provisional remedies, each of each section 1 of each, mentions when the application for the remedy to be had. So the first one is preliminary attachment. Rule 57, Section 1, it is said there that at the commencement of the action or at the start of the action or while the action is begun or at any time before entry of the judgment. So this is the preliminary attachment. Number 2, preliminary injunction. At any stage of the action prior to the judgment or final order. In other words, the same with the preliminary attachment, you can still apply even at the commencement of the action at any stage of the action prior to the judgment or final order. Section 1, Rule 58. In receivership, Rule 59, Section 1. At any stage of the proceedings and even after the judgment has become final and executory as means of enforcing judgment. Why? Because this is to preserve the thing in dispute. So even after the final judgment, a receivership when it is practical, uh, it can be applied for. So to preserve the thing that is in dispute, or even not in dispute anymore, but there is already a final judgment of who, but still it needs, or it is applicable for a receivership to a receiver to preserve it. In Repleven, that is Rule 60, Section 1, at the commencement of the action or any time before the answer. This is very short. So, by the time that you commence the action and you have to apply for Repleven uh, before the answer can be had. So, this is the answer of the defendant. Okay? And number 5, support pendentilite. In Section 1, Rule 61, at the commencement of the prior action. So, there is a prior action. Of course, this is a provisional remedy. Or proceeding, or at any time prior to the judgment or final order. So, you can now say that most of them can be had before any entry or on the final judgment or final order. Only Repleben, it has a short time because you can only have this before the answer. Okay, but receivership, even there is already a final judgment, you can still apply for it. So these are the time and application for provisional remedies. So next time next video, we will be talking about preliminary attachment. Thank you.